Trace admission item number 1.
None appears for the petition. This was not prosecution.
Supplementary trace admission item number 2.
None appears. This was not prosecution.
Item number 3.
Case was listed on 4/1/2024.
Tell us about the main writ petition.
The prayer in the writ petition have submitted given petition before the opposite party 1 to 4, my lord. They have not taken any steps, my lord, against the opposite party of
So this is
5.6.
service matter.
5.6, my lord. And
No, no.
5.6, by producing manipulated certificate before the authorities, they have got promotion to the post of ORS. And also
So this is a PIL or is this, what is it?
PIL, my lord.
Service matters, there can be no
It's not
PIL.
a service, my lord. It's service not petition.
Promotion is what?
But petitioner never claiming any service benefit. But petitioner approach the authorities.
See, we can't have a PIL in service matters.
Petitioner never claimed any service benefit. Petitioner brought to the notice of the authorities.
You're not following the issue, sir. In service matters, we don't entertain PILs.
Only to your lordship may direct the authority to consider my grievance. That is the annexure
No. We're not entertaining.
18, my lord.
The prayers in the present petition pertain to the realm of service law. No PIL is entertainable in a service law matter.
So the opposite of 5 and 6 by submitting fake certificate, they have got
petition is-
promotion to the post of ORS, my lord.
The court is therefore not inclined to interfere. The petition is dismissed.
Item number 4.
Challenging the order of mind order that is 18/11/21, the order of the receiver. Agreed, my lord. To annual increment to delinquent is stopped, my lord. The cumulative effect.
I'm not able to hear you at all. Are you able to follow what you say? I'm not able to follow what you're saying.
My lord, there are petition challenging the order of disciplinary proceeding, my authority. That is order dated 18/11/21, my lord, annexure 6, my lord. The petition-
Unauthorized absence. So continuous absence, you're not interested in work at all, it seems.
My lord, that is due to that the office authorities are not allowed the petition to sign in the register, my lord. Because that is the problem, my lord.
Standard excuse, sir.
Every day he went to the office, but he is not allowed to, because,
We're not believing all this, sir.
because that is they allow the petitioner not signature in the any office paper, my lord.
What?
But not allow the petitioner to sign in the register, my lord.
All right. What do they say in the counter?
And counter is not received, my lord. The fresh case, my lord. And also they not supplied the documents on basing upon which they're taking action, my lord. Annexure 2, I tried to supply documents, but not supplied any
Where's the
documents.
question of not allowing you to join? Allowing you to sign register?
My lord,
What were you working as?
the peon come or orderly come peon, my lord.
No, on a regular basis.
Yes,
Where do you say that? Where do you say that you were regularly appointed as orderly peon? Where have you said that? Nowhere said. I think it must be a daily wage. Let's read the report, sir, annexure 4. or Annexure 6 even better.
My lord, that is the order of
Yeah.
my plea that not allowed to me sign the register and also not supply the document. My lord, Annexure 2, I sought for documents to supply, not supply any documents.
This is the third department proceeding, sir.
Well, only due to
Page 56, come to page 56.
Only due to that only dispute that is my lord.
No.
They're not allowed to me because
Just come to page 56, para 12.
my lord. That's
Then,
because they compelled to petition to do any household works, my lord.
nothing, sir. Only 2 annual increments have been stopped for so much absence.
Well, Agur, the
And 3
previous-
misconduct, 2 acts of misconduct in just 5 years. You're creating a record for yourself. In 5 years, 3 misconducts, 3 DPs.
previously two, my lord. That's why that is I also taking salary is much low, my lord.
The petitioner who's working as a Group D employee in the office of the district judge at Jaskoda has assailed an order dated 18/11/2021 passed by the discipline authority, that is the district judge. Dismissing the petitioner's objections to the inquiry report and rejecting his plea that his unauthorized absence was that his absence for duty was pursuant to casual leave being duly sanctioned to him. It appears that from the record that the petitioner was a chronic absentee and remained on unauthorized absence between 3rd and 7th March 2019, 21st March, 3rd April 2019, 7th April to 15th April 2019, and 16th to 25th April 2019. The district judge found there was no material placed in record by the petitioner to enable him to come to a different conclusion. Paragraph. The only defense of the petitioner was that he was not supplied with documents during the inquiry and was not given an adequate opportunity to defend himself.
And my plea was not discussed by anywhere, my lord.
And his plea and merits was not discussed. Full stop. It is noted in para 12, the order the district judge is under, take whole of para 12, page 56. In the above background, with this being the third disciplinary inquiry against the petitioner in a short span of 5 years, clearly, and with there being no defense on merits, which can explain the petitioner's absence for such long periods, the court is not persuaded to interfere the impugn order of the learned district judge. It is also noted that the impugn order gives a minor punishment of 2 annual increments of the delinquent being stopped with cumulative effect. So this is yet another reason why the court is not inclined to interfere. The writ petition is accordingly dismissed.
Item number 5.
Lord, I am Ashok Millard, I am in BC.
Yes.
Lord, your Lordship's senior court manager and court managers are before your Lordships for the second time, Lord. Earlier they came, they didn't get any increment except one increment, even though contractual service rules provides for annual increment. Then, my Lord, right from 2000.
So they have not yet been regularly appointed.
My Lord?
They're still on contractual, right?
Yes, they are continuing still on contractual day.
So a decision may be taken very soon. Mr. Manti, what we'll do is we'll take this up in sometime in end March.
Milord, that will be taken up, your lordships, High Court recommended for Group A because their salary, present salary didn't fit into the.
No, all that is fine. No, all that is fine. My only point is this.
Yes, sir.
Once we know the position on how many of them are going to be regularly appointed, we might be able to make two categories here.
Milord, the recruitment Group B rules provides for a suitability test, Milord.
Correct. So all that we expect because of COVID, all that did not happen. We had earlier fixed some.
I am challenging the recruitment rule itself, Milord, without prejudice, Milord, that may continue, Milord, but your lordship may issue notice in this case because all other high courts, Milord, I have given 2 high courts, Milord, they have appointed in Group A pursuant to the direction of the Honorable Apex Court. Your lordship must be knowing everything, Milord.
No,
because it is more or less your lordship's recommendation that they should be fitted into Group A.
Right.
And that was in 2016, and they must be regularized. Instead of that, they are now telling that we have floated a recruitment rules. That procedure will be followed. But the recruitment rules is for adjustment in Group B post, Milord. Without any basis, how can they adjust it in Group B post, Milord, against a lesser scale of a where the scale they are getting was in 2016-17 couldn't have been fitted into that scale of pay before the 6th pay commission, Milord. And moreover, Milord, they must come out with a validation act, Milord, like all other high courts has done. Instead of that, they have gone for a Group B recruitment rules, Milord.
Yes.
That is what I say, Milord, that it is irrational, Milord, and arbitrary, Milord.
All right.
And it will be discriminated. Therefore, your lordship may. And look, once the Honorable Court says that you regularize them, can the Home Department sit over it? And how can the Law Department prescribe a scale, Milord?
Mr. Monty, the only thing is, if that exercise of how many of them are going to be appointed takes place on a regular basis, then we may have a different treatment for some of them.
Your lordship may keep this matter pending and proceed with the recruitment proceeding, Milord.
That's right.
Without prejudice to my claim.
That anyway is without this. We are not, writ petition is pending anyway. It's okay. So list on, you simply say list on 28th March.
Let the government file a response, Milord. It is not for the High Court to file a response because it is the government action that is being challenged.
No, do you want us to issue truncated notice only for validity?
Milord?
Should we issue a notice only limited to the validity?
Validity and regularization, Milord.
No, so regularization will not, that's a premature thing because that exercise is still going to take place, Mr. Monty.
Then under the recruitment, present recruitment rules, that is what my grievance is.
Yes.
Under the present, once I succumb to the present recruitment rules, I do not have any claim to be adjusted in Group A.
Succumb. There's no question of succumbing. Anyway, so we'll issue notice on the validity. The challenge to the validity, we can issue notice.
All right, Milord.
Notice at this stage limited to prayer 2, which is a challenge to rules 3, 6, 12, 18 and 19 of the Orissa Senior Court Manager and Court Manager of the High Court and District Courts, bracket, method of recruitment and conditions of service, bracket, rules 2020, as being unconstitutional.
1/6/2020.
Notice is accepted on behalf of. What is Government of India to do with this?
The Government of India only, those instructions has been issued
No, no directions are sought against Government of India.
No.
So at the outset, you say opposite party number 5 is not a necessary party and is accordingly deleted. The amended memo of parties be filed within a week, and then this notice is remitted. Notice is accepted on behalf of 1, 2, and 3 by
4 roles.
No, but 4 can't be. I mean,
1, 2, 3.
by Mr. P.K. Mudali. Learned Ashley Government Advocate. Reply be filed within 8 weeks. Adjourned to next date. List on 28th March.
Prayer number 2 and 3, you are not sure.
No. The other prayers will be considered on the next date. Right.
The law department is consequential to that recruitment rules.
Right. So let them file a reply to that, sir.
Okay. Well.
Supplementary list for item number 6.
Right.
Item number 6, my lords, I pray for a modification of the order dated 3/1/2022. Only in the first paragraph, my lords, I have filed a IAD flag X for modification, my lords. Only in place of learned district judge, it will be director of estates.
Audit. Allow this straightforward. Audit.
My lords, the last date was 7th of February. My lords, I pray for a week's time, I will file it, my lords. For filing it before the learned district judge, my lords. I pray for a week's time, my lords.
The time for filing before the time for filing is extended by 1 week. That is up to 14th.
Grateful, my lords.
Audit.
Item number 7.
May I please, Your Lordship? I am here on behalf of Mr. Anjan Kumar Biswal. I have no instructions, my lord.
Audit. Counsel to petitioner states he has no instructions.
Item number 8.
Lord, one matter related to Kalyan Mandals. Pursuant to your Lordship's order, learned senior activists have a copy of the affidavit filed in court, my lord. What my learned senior stated in their affidavit that 74 mandals have granted license. This is the crops of the affidavit filed by my learned senior. Now, as far as the CMC is concerned, pursuant to your Lordship's order, they also filed an affidavit where they stated that they made an contractual agreement with CRISIL Bombay on 16/8/2021, which was they framed the draft regulation within 5 months. They filed a draft regulation on 22/11/2021. But they stated in their affidavit that it will take time further before finalization of the draft regulation. Objections and suggestions are to be invited from the public in general. It shall be finalized after hearing them. However, it shall take some time because of COVID-19. What I stated, my lord, if the CRISL draft sent to the government and objection will be called for from the public, when it will take some time, what I pray, my lord, and rule framed by this honorable court on 9/11/2016, till then, that rules can be continued, my lord.
That anyway is continuing.
So,
Exactly, I want to submit with permission, my lord. If your lordship,
absolutely not, my lord.
if your lordship looks at 9/11/2016, the guideline that has been fixed by this honorable court, the report of the committee, my lord.
Right.
But that guideline is being followed from time to time with certain revisions with the undertaking given by the mandap owners, my lord. But the city that has also been taken note of by the affidavit of the municipality. If your lordship kindly see the affidavit of the municipality, that was way back it was filed. If you lordship kindly look at that affidavit, my lord. The previous affidavit, not the present one. Present one, actually, they have changed their stance.
Yes, my lord.
The previous one, after if your lordship looks at 3/8/2016, that affidavit itself will show that they also agree with the condition that that order of the Honorable High Court should be complied with. And on that basis, actually, the modality has to be fixed. And on the basis of the modality, the license is to be granted. And there's a temporary license and with a conditional license that they have to comply with the conditions that has been laid down. But anyone violating the condition, they have also imposed penalties like 20,000 or 30,000, whatever be that. But all those things have been reflected in the counter affidavit of the municipality itself. If you also kindly look at that affidavit, paragraph 13.
Yes.
14. But if you also permit me, they have highlighted this municipality's affidavit. Let's say in paragraph 13, the deponent therefore humbly submits that the following facts for kind consideration of the Honorable Court for greater interest of the public general of Cuttack city. They say Cuttack is an oldest city of Orissa on the river bank of Karjodi and Mahanadi, having development history of more than 1,000 years. This commonly known as millennium cities, they have themselves mentioned. As per census 2011, the population of the Cuttack Municipal Corporation was 6.10 lakhs. Now it is more than 7 lakhs. But over the period of time, the city has experienced both horizontal and vertical growth. It is also a fact that horizontal growth of the core of the city has been restricted by Mahanadi and Karjodi, and restricted horizontal space by expansion and history of organic growth. Cuttack is having indigenous development characteristic, especially the core city of Cuttack, intertwined gullies, mahalas, bazaars, limited rights of ways, narrow lane, dense building form, and landlocked area, unsafe connectivity along with overloaded infrastructural facility. And you must have experienced by now, the entire Cuttack city, you must have seen. But they have therefore indicated in the core city demanding a separate set of planning and building standard regulation. That will take some time. Therefore,
Let them take that time. I mean, they need 3 more months. Let them have that 3 more months.
They have suggested Kalyan Mandaps and marriage halls, community hall, etc. No doubt the mandaps are operating in demand interlinked with social fabrics mirrored. And they have also indicated about the previous regulation that fixed by the Honorable Court, and they wanted that.
As long as, so even Mr. Budhia is saying the same thing. He says till the new regulations come, the 9/11/2016 order will be followed.
And that's right. 9/11/2016 regulation has to be followed, the guideline has to be followed, and they are to be abide by the same.
Mr. Nayak,
My lords have to give a clear direction on this. Because what has happened in the meantime is this 9/7/2016 regulations of the Honorable Court. After these regulations were being followed, 2000, the later guidelines, the CTA regulations that came into force later, much later, those had very strict guidelines. So my lords then were of the opinion that the new guidelines should be followed. This entire controversy is because of that. So if my lords now give a clear direction that we will follow 2016 guidelines, we'll do so.
Yeah, 2016 order, if your lordship looks at Millard. And at Annexure 6 in my writ application, page 42. That is WPC 3979 2015 order. I have annexed it, my lord, in my writ application.
Order number 17, my lord.
Order number 17, correct.
Yes, my lord.
so we'll clarify that then.
That may be clarified. You also may indicate that, because until the new set of guidelines comes, this has to be followed.
All right. And an affidavit has been filed by the CMC on
The 25 1, my lord.
sorry,
25th January.
25th January 2022, stating inter alia that CMC has engaged the services of Chrysler.
Yes,
This is not the same Chrysler, I think, my lord.
I see. Engaged services of a consultant, CRI SIL, for preparation of the CDA bracket planning and building standards for core areas bracket regulations for developing the core areas of Cuttack. It is expected these regulations will also deal with the issue of construction of Kalyan Mandaps in the core area. Paragraph, Mr. Budhia, learned counsel for the petitioner.
Amicus curiae, my lord.
Sorry?
He is amicus.
Learned amicus curiae states that this court's order dated 9th November 2016 should hold the field and continue to operate till such time the new regulations are framed. Full stop. This is also the plea of Mr. S.P. Mishra, learned senior counsel, as well as Mr. Nayak, Mr. Devashish Nayak, learned counsel for the CMC. paragraph. It is accordingly clarified that this court's order dated 9th November 2016 will be strictly followed by all concerned till such time the new CDA regulations are framed.
May I pray, my lord? They are not follow the 9/11/2016 till today. To that effect, time and again your lordships passed different orders. But they are not
any individual cases of violations, you say any individual cases of violations
my lord.
will be brought to the notice of this court by the learned amicus curiae by filing an appropriate application.
Violations of the 2016 guidelines.
Yes.
Yes, of the courts.
Yes. Deeply obliged, my lord.
List on 11th April, sir.
11th April, sir?
Will it be done by then?
June, I think the affidavit states June. June 22. Page 3 of the affidavit.
All right. List on 21st June then.
Okay.
Too long, my lord. May I pray? Let it be on 11th April. In the meantime,
The
I will
guidelines are
verify.
already being followed. The guidelines are already, my lord is just given those guidelines, they clarified.
Once the court's guidelines continue to apply, that should be no problem, Mr. Budhia.
My lord, I have to that effect, I have already filed a miscase that they are not following at all, my lord.
You just bring individual note.
I have already properly
I think
referred, my
it's
lord.
better if you do. I think if you bring individual cases to our notice, we list them earlier. List on 21st June.
Okay.
Supplementary list item number 9.
My lord, item number 9, it's a PIL matter, my lord. The petitioners are challenging the inaction of the opposite part number 7 in regarding misappropriation of public fund, my lord.
You go to the Lokayukt, sir, if any cause of action survives. You say if any cause of action survives, it will be open to the petitioner.
Representation to the opposite party number 4, my lord.
For the
That may
grievance
kindly
made
be
in the present
directed to
petition
before the
by filing a proper application in accordance with law. The petition is
Item number 10.
none appears dismissed for non-prosecution.
Item 11.
None appears.
Item 11, I pray 10 days time to file the legible copies.
No.
File
Not,
a date chart for hearing.
no, sir. 2019
Okay,
matter.
sir.
Tell us what it is about.
I have challenged the Annexure 11, that is the appeal committee decision. Annexure
What is that?
11, page 48. Where the appeal committee, page 48. The appeal committee has not considered all the grounds taken in my appeal.
No, see 9. Report 9.
The grounds taken in my appeal in Annexure 10, none of the grounds have been considered by the appeal committee and the appeal has been rejected.
No, it's not supposed to be an elaborate order. It's just an appeal.
That is the grounds I have taken in my appeal that Circular 46 have not been followed while rejecting my promotion. In my appeal, paragraph, I have also enclosed the book circular in enclosure 8 in my appeal. Para 10 I have mentioned.
Let's see that.
Para 10 in my appeal, page 41.
Page?
Page 41. Page 41 in my appeal. Para 10. That the remarks recorded in the CCR of the petitioner is illegal and honest in the eye of law, because as such remarks no action can be taken up. The petitioner was transferred from the office of SDGM Karanjia to the office of SDGM Udala on 18/9/2022. As per this book circular number 46 dated 5/2/82, the concerned officer has to submit the CCR within 2 months from the date of transfer, that is latest by 30/11/2022. The SDGM Karanjia has given remarks in CCR of the petitioner much after the transfer of the petitioner with the in the year 2003 again, with the malified intention to arise. Apart from that, the CCRs to be maintained in the remark column
in each financial year, and the report period will be 1st April to 31st March in the accordance with the para 3 of the book circular number 46. But the remarks have been recorded in CCR of the petitioner for the year 2022 at the time, and same had been communicated to petitioner in delay, that is on 28/6/2003. Copy of the book circular has also been annexed. The said recording is not in accordance with the rule. Copy of the order dated I had also annexed in the.
Anyway, you have to
in the
remove defects
CCR.
also, it seems, sir. Defects also
Yes,
have
my
to
lord.
be removed.
I will remove the.
All right.
Copy has not been
Yes,
solved.
within 1 week.
That is
Yeah,
one of
that's
the
a
defect.
Defects be removed within 1 week, list thereafter.
Item number 12.
Oblige, my
May I please? My lord, this case is a public interest litigation. The petitioners, they have filed the case for the Gram Panchayat without following the guideline that is passed by the state government Panchayat Raj Department 8/11/2017. They are going to construct the Kalyan Mandap. That the government guidelines stated that the
So by now it have been
By now
it should have been
must have been
constructed.
completed.
By now it would have been constructed, sir.
not been constructed, it is half constructed.
No, no. How do we know that?
The super instruction is concerned.
No.
The petitioner
Mr. Monty, you are appearing.
Yes.
Mr. Monty, learned AG, appearing on behalf of the opposite party state, seeks and is granted time to seek instructions on the current status of the construction of the Kalyan Mandap. That is request list on 8th March.
Whether that has been alienated or that has been purchased by the Gram Panchayat before this time or prior, that may be also they should be instructed to take the instruction
All
with
right.
that regard.
All right. Yes.
Item number 13.
Oblige.
Your Lordship, this is an ex parte assessment made when the return income was shown at rupees 17,59,000. Estimation was in ex parte made 1,11,65,000. There is a demand. That is business is paddy selling. Your Lordship knows that paddy selling has a lot of politics.
So this is an appealable order, sir.
This order is appeal. Only I have come to Lordship because 87,11,000 demand. They demand made. The 17,42,000 they said pay 20%. I'm unable to pay because business is.
This is in 2020. By now, what has happened? What have they done? Because
only your Lordship direct that appeal should be disposed of within 2-3 months. I can deposit money because I'm unable to pay money. Total hardship and there is bereavement in the family also.
What has happened, sir? This is 2020. You filed it.
Page 13.
Appeal pending.
Page 13. Against that order of the 20% just preferred revision before the commissioner.
And
I'm just asking whether it is disposed of or not. Your Lordship directly not dispose of within 15 days or 10 days. And appeal cannot be entered in without.
It is seen from the
appeal pending. Appeal pending. You have a Lordship direction by the.
Not appeal, sir. Against the 20% deposit order, you've gone in revision. Is it?
Because direction is pending. Petition appeal
the order requiring the petitioner to deposit 20% of the demanded amount as a condition for hearing the appeal. Not condition.
Not condition.
As a condition for stay.
Stay.
No, it is not condition.
Of recovery. The petitioner appears to have filed a revision petition before the commissioner.
Before the commissioner, income tax range
Income
1.
tax, range 1. If the said revision petition has not yet been disposed of, should be disposed of.
If not disposed of, because I have not taken instruction of the disposal.
If it has not been disposed of, it should be disposed of within 4 weeks. And any event not later than 14th March 2022, and the order be communicated to the petitioner not later than 21st March 2022. The court clarifies it has not expressed any view in the matter. No further directions are called for in the present petitions disposed of.
Item number 14.
Disposal of appeal can also made.
14, my lord, it has become infructuous.
Counsel, the petitioner states that this petition has been rendered infructuous, disposed of.
Item 15.
Your Lordship, 1 week time may be given for removal of defect.
Or defects. Counsel, the petitioner states that he will remove defects within 1 week, list thereafter.
Appearance of never noted, my lord.
Yeah. Item number 16.
May I please, Your Lordship? I am on 59. Madam, this is a writ petition of public interest nature, my lord. Here.
You are not audible, sir.
My lord. My lord, this is a writ petition of public interest nature, my lord. Am I audible, my lord?
Now you're better. Yes.
My lord. My lord, here, the sub-collector Puri, that is OP number 2, has selected the school campus for construction of Gram Panchayat office, my lord. The public opposite of decision, my lord. Further, it falls within the ecosystem.
So these representations, how do we know it's been delivered to the collector?
My lord. Pardon, my lord.
All right. There are stamps. All right. The petitioner's representations dated. Who has to consider these representations?
My lord, collector Puri.
Have to be, dated 8 March 2021, be examined by the collector Puri. Opposite party number 1. And after notice to the petitioners and after giving them a hearing, a reasoned order be passed thereon. Not later than 2nd May 22, and be communicated with petitioners not later than 9th May 2022. If agreed to be open to petitioners to seek appropriate remedies in accordance with law, the court clarifies it has not expressed any view in the matter. The petition is disposed of there.
Item 17.
My lord, item 17, there's a PIL file for directions during the COVID-19 shutdown and lockdown.
It's infructuous then.
My lord.
Counsel for the petitioner states that the subject matter has been rendered infructuous. Is disposed of.
Item number 18. Supplementary list item number 18.
None appears. This is not possible.
Item number 19.
May I please, my lord? My lord, there are some defects.
Defects be removed within a week. Yes, there are.
Item number 20.
My lords, there are some defects.
But let's defect be removed within a week. List thereafter.
Item 21.
My lordship, sir. But here, the petitioner calls in question the legality and propriety of order dated 6/8/2021 passed by the collector and the district magistrate Baleshwar, rejecting our grievance for illegal construction of Angaran center over plot number 14/102.
You want the center to be constructed?
Yes, I have mentioned that should be constructed within the campus of the government land. That is government.
Who's opposite party number 7?
Yes, but
may I come in for a moment? Who's opposite party number 7? Sir, who's opposite party number 7? It's frozen.
What is appeared, I think.
Who's opposite party number 7, sir? What is his role here?
That is the OP number 7. But OP number 7, that is the person which that is the contractor, work order is issued to him. OP number 7. That he has not appeared. But here my case is that the Angarwadi center, as per the guideline, Angarwadi center should be established over a government land within the campus of the primary school or high school, whatever may be. That is the guideline, and that should be constructed having no objection to area. That is, there is no objection. There must be no objection.
Where is the collector's endorsement on your representation? Receipt.
Yes, because I can see that. But last time I had that is page 19. Page 19. Sorry, yes. Page 19.
What is it?
But that, yes, given its findings, before, no, sorry, before, page 18, sorry, page 18, before that, page 19. But the CDPO made it, not?
Yes.
The CDPO Municipality Baleshwar submitted PwC that the land is verified by Tahsildar Sadar Baleshwar and proposed the site for construction of an Anganwadi center building on plot number 14/102 on his letter number so dated 6/10/20. The land is suitable for Anganwadi center building. There are no.
Heard this, no?
Yes, last I have that. And directed.
Lordship, let me come in for a moment.
Yes.
Lordship, may see the
rough sketch.
last
You want
order?
to show the rough sketch.
Yes.
What happened?
I have e-filed the
Lord, on 7th of this month.
No, have you given it to Mr. Patnaik?
Yes, I have also saw the copy.
You got a copy, Mr. Patnaik?
Yes, I have got it. Today I got it. Today I got it. Today I
we
got
don't
this
have a
copy.
copy. We don't have a
But,
copy.
but government has not filed any counter also.
No, your lordship has directed me to open instruction whether there is an approach road connected to the particular spot and the current. Yes, my lord. In fact, I have the additional copy if lordship wants to.
Yes, 1 minute. Sorry.
And the report also was submitted by the sub collector. He says that there is an approach road to the Anganwadi center which has been used for construction.
102 plot is a green one.
Yes.
Yes.
And where is the roads, approach road to that?
Lord, 269. Your lordship is
Annexure 4.
Lord, page 3 of my report. Page 3 of my memo. Just show you. Petitioner file. Lord, this document has been filed by the petitioner.
Oh, where is your?
Lord,
the rough sketch stated to have been filed by Mr. Das has not come on record. We'll call it next week, 22nd February.
In the meantime, let them file a counter so that it will give
No, let's see the rough sketch, ma'am.
Yes.
Item 22.
Please, my lord, here, basing on the grievance by the villagers of the Harirajpur, they have also making a agitation before the collector as well as all the revenue authorities that their Gram Panchayat, the village should not be merged with the newly formation of that Tahsil, namely Dampada. And there was a direction to the sub-collector to make an inquiry and give a report. The sub-collector, my lord, the Banki also make an inquiry, gave a report to the collector.
So many defects.
Only, my lord, it can be disposed of only because the commission of the opposite party number 2 want to take a decision because the report is already there submitted by the sub-collector before the collector, and collector also given that report to the secretary. So he can take a decision with the stipulated time. That is it.
All right. Direction is issued to the Secretary, Revenue and Disaster Management Department, Government of Orissa, bracket opposite party number 1, to examine the report dated 17 January 1999 of the Tahsildar Banki, bracket annex 2, as well as the representations.
Villagers of Harirajpur.
Annex 1. And after hearing the petitioners, to give a reasoned order. Again, not later than 4th April 2022. And make the order available to the parties not later than 11th April 2022. The court clarifies it as not explicitly in the matter.
Item 23.
Item 23, my respectful submission, my lord, Annexure 8, appeal is pending before it.
You have to remove the defects also, sir. Defects we remove within a week. List thereafter.
Item 24.
My lord, I am appearing on behalf of the petitioner. This present application is filed for restoration of writ petition as dismissed due to non-appearance the advocate of the petition.
What's the main petition about?
Sorry?
What is the main petition about?
So, my lord, it's a PIL.
What is it about, sir?
My lord, actually, yesterday I got this brief. So, kindly give me some time, my lord.
What is that? Yesterday?
Pardon? I got Vokalat now, my lord, yesterday.
Yesterday, he got the Vokalat report.
At the request of counsel, the petitioner list on 16th March.
Item 25.
Lordship, item 25 weeks time may be given for removal of defects.
Item 26.
This is a PIL relating to bauxite mines in a very remote district of Koraput Milan. Dear my lord, the manner in which the public.
This is already a pending matter, no, sir? No.
No, my lord, they have concluded the public hearing and got out the report by Annexure 8, my lord. This is not the Paradip case. This is not Paradip. This is in Koraput, my lord. Somewhere else.
No, I know that.
Malipadgat. Yes, my lord. There, my lord, before 3 kilometers from the spot, barricades were made to prevent the people who were obviously coming to oppose such project, my lord. And before the prior the date of fixed for public hearing, many people, many villagers and Mali Suraksha Parishad members, they
What
were
is the current position, sir?
The current position, my lord, environment clearance has not been given. And before that clearance, this public hearing was made for the purpose, my lord. Now, by the Annexure 8, they have prepared a report with handful of men, mainly opposing the people who were opposing, they were obstructed not to come. And before 1 hour of the scheduled time, the meeting started, it was over by within 1 hour, my lord. And that is the only, my lord, this is the only limited grievance of the people.
My lord, so far my preliminary instruction is concerned, the public hearing was conducted smoothly on that particular date. The proceeding, he has annexed it as Annexure 8. And now he's at a later stage, he's alleging that some persons were not invited.
No, I remember there are some contemporaneous reports on this, Mr. Monty. Just you have to examine this. The grievance of the petitioners in this PIL, the grievance of the petitioners who are residents of villages Maliguda, Kankadan, Kakriguda, bracket petitioners 1 to 4 bracket in district Koraput, is that they were prevented from participating in the hearings conducted by the State Pollution Control Board in connection with the grant of environmental clearance for the project of, for the bauxite mining project, is it?
Yes.
Yes, sir.
Of opposite party number 8. Full stop. See, notice Mr. Manti accepts notice for opposite
3, 4,
parties
5.
3, 4, and 5. Anyone else appearing?
3, 4, and 5, and 7.
3, 4, 5, and 7. Anyone else is appearing today? All right. Notice we issued to the remaining respondents by registered speed post. Returnable on 10th March 2022. The tracking report we placed on record. Mr. Manti will file the affidavit of the collector Koraput.
ADM, my lord.
ADM Koraput. Specific to the above grievance of the petitioners before the next date. At least 1 week prior to the next date, with an advance copy to Mr. Jaina, learned counsel petitioner, who is permitted to file a rejoinder that. Paragraph Mr. Jaina states that to the best of his knowledge, the petitioner's knowledge, the environment clearance has not yet been issued. Full stop. If in the event that no EC has been issued as of date, it will not be issued till the next date. List on 8th March. 10th March. 10th March. All right.
Item number 27. Item number 27.
Yes. Oh, yes.
Item 27, supplemental list.
Defect we removed within a week. Is there?
Dilip Kumar Sahu.
Mr. Dilip Kumar Sahu. You're not audible, sir. Pass it over. Pass over.
Item 28.
My lord, this is a PIL, my lord, a very sensitive matter, my lord. My lord, your lordship may kindly come to page 14, Annex 1. A film has been released in the name of Mr. Kanhaiya. It's a Odia film, my lord, in the name of God. And here God and goddesses are dancing with the tune of Cheer Girls, my lord, in a drunken state. And wine bottles are there around, my lord, Lord Krishna.
So what is the certification for this?
My lord, this is a certification.
What is the censor board certification for this?
Censor board certification, my lord, the censor board chairman should have verified while giving certification.
No. What is the factual position on censorship here?
My lord, certificate.
When was censor certificate issued?
Yes, my lord, this certificate has been issued thereafter this film has been released, my lord.
Correct. When was it issued, sir?
My lord, that we do not have that.
No, you should find out, sir. Please do some basic homework. What is this going on?
My lord, since it was very sensitive matter.
No. All your sensitivity means you should do extra homework for sensitivity, not rush.
My lord, we will do definitely.
Please do that. Find out if it's adult certification or what.
My lord, this film has already been released throughout the entire state of.
Correct. All the more you better hurry up. When you watch the film first, they will show you censor certificate. Correct?
My lord.
That will give you date, everything. What is the type? Is it adults only or what is it?
My lord, it's adult film, my lord.
So adults only.
It's adult film.
So nobody is under compulsion to watch this.
No, my lord, it affects the Cinematography Act, my lord. Your lordship may kindly see section 5B. Well, that cannot be do so.
Yes.
Section 5B, if your lordship will allow me to read, my lord. Only few minutes, my lord, I will take.
First, tell us when was it granted certification? When was it granted certification, sir?
My lord, for a moment, my lord. I will definitely.
First place the full facts.
I will obtain, my lord. I will obtain, my lord. Within very short, limited period, my lord, I could not obtain it because it was a very urgent case and it was, my lord, immediately released throughout all Orissa film halls, my lord. So that is why I could not obtain it. Your lord,
so the threshold for court interfering these matters is very high. All right.
My lord.
Everybody is hurt by something or the other and they rush to the court.
My lord.
We can't be interfering in anything and everything.
My lord, this matter.
There is an expert body which views these films and which applies the guidelines and grants a certificate.
My lord.
Correct?
My lord.
So we have to be satisfied that first of all that the expert body did not do its work.
My lord.
For which you have to give us details of what is the expert body certificate.
My lord. With due respect, my lord, I will definitely verify, my lord. But recently, my lord, I should not do it, say it in open court, my lord.
No, don't say it then. See, what happens is you say these things and say exactly what you don't want to say. Don't say it. This is not advocacy.
My lord.
Please don't say it. So first do your homework and then come back.
My lord, for a moment, section 5B, my lord.
Sir, unless we see the section is there, but we do not know the contents. We do not know the contents. You don't have a transcript.
My lord, one of the member of this, my lord, authority, my lord, yesterday in a, my lord.
You don't know, if you're not pleaded all this, don't say these things, sir. Is that what you're going to say? Is it in the pleadings? Is it in the pleadings?
My lord.
If it is in the pleadings, read out from the pleadings. If it is not in the pleadings, don't say anything orally.
My lord, yesterday itself, my lord.
No, if it is yesterday itself, then you file an affidavit. First, tell us about the censorship certificate. If you do not have the details, find out and tell us. Mr. Monty, you can also find out.
Yes.
The petitioner is unable to inform the court when the censorship certificate was issued by the Central Board of Film Certification, bracket opposite party number 3 for the film in question. He needs time for that purpose. Mr. Monty, learned AGA, appearing on advance notice for opposite party number 1, states that he will also seek instructions in this regard. List next week, 15th.
My lord, may I pray a short prayer, my lord? The scenes which is right now under my lord challenge, my lord. This scene may not be displayed before in any cinema halls.
We won't interfere like this piecemeal. Sorry, sir. Without proper details, we will not interfere. Yes.
My lord, another prayer, my lord. The Lord and State Council may be directed to take instruction whether the norms and conditions has been followed before granting.
No. First, you give us these details. Then we'll see. Yes.
The date may be fixed, my lord.
Yes, we fix the date, 15th.
Item 29.
May I please, my lord? My lord, item 29 is a public interest litigation, my lord. My lord, Chilika Lake, the Mangala Jodi is situated in the northern part of the Chilika Lake, my lord.
Mr. Who is appearing in this?
Myself,
one minute, Mr. Just find out, is this a recent practice that they allowed? Because from what I've heard in Mangal Jodi, no boat race boats were ever allowed.
Yes.
If it is a recent practice, you find out why they started this practice.
Yes. Motorboats.
Because I think this area, no motorboats were originally allowed. And why did they start it? Who started it?
Yes.
The grievance made in the present petition is about motorized boats being permitted in Mangal Jodi water body. It is stated that this was never the earlier practice, and such motorboats ought to be restricted since it disturbs the migratory birds which abound in great numbers in Mangal Jodi.
India.
Every year. Paragraph, you say, notice, Mr. Das accepts notice on behalf of the opposite parties. He has been asked by the court to seek instructions on whether the practice of allowing motorboats was started recently and the reasons therefore. Full stop. The divisional forest officer, Chilka Wildlife Division, Balugaon, is directed to remain present either physically or in virtual mode.
Instead of VFO, the Chief Executive of Chilika Development Authority.
Alright, the Chief Executive Chilika Development Authority is requested to remain present in virtual mode to explain to the court to answer the queries of the court. Full stop. Can we have it on Friday?
Yes.
List on 11th at 10:30. We'll take it up as the first item on 11th. At 10:30.
Admission item number 30.
May I please your lordships? This is a writ application. I am on virtual mode, my lords.
Yes, please. Yes, please.
My lords, this is a writ application where some of the lands of the petitioners were notified under section 4 and 6 for acquisition.
Right.
If your lordship will kindly turn to page 8, the counter affidavit of the Tahsildar, page 18, paragraph 14. Paragraph 14 is a very old counter affidavit. My lords could get it. Counter affidavit filed by Sri Sukadev Das, Land Acquisition Officer, Dhenkanal Collectorate, my lords.
Right.
My lord, it's very old counter affidavit. It has become yellow. The papers have become yellow, I think.
Right. Yes.
Minutes, can I place it?
Yes, please. Yes, please.
Paragraph 14, last portion. But LA case number 19 of 79 was started for acquisition of acres 20 decimals from plot number 1434/1503, which was processed till the stage of declaration under section 6 within bracket 1 of the LA Act. By Revenue Department declaration number 37349 dated 7/6/1983 and published in EOG number 1548 dated 23/11/83, but was subsequently invalidated. Because there is no notification under section 48 of the then act saying that it has been invalidated. But if I will show Millers from the records itself, the lands are in the government took possession of these lands, handed over to the beneficiaries, and one of the beneficiary has now come and said that it is within my boundary, I am prepared to give it to them. If your lordship will kindly see, since 79, I have also issued earlier a notice to the collector. You have acquired my land, you are not giving any possession. No reply was given.
Why don't you read the order, sir? 1811 order.
1811?
2021 order. Passed by this court.
Yes, sir. I think I am missing it.
The detailed order. This is OJC 4 of 95, no?
Yes, madam.
Yes, madam.
Detailed order has been passed with this court. Several detailed orders have been passed in the past that we have passed on 18 November.
I am not seen. Maybe I have missed.
You have it, Mr. Mohanty.
Yes, madam.
You can read it.
Madam, just. One minute, yes.
देखिए बाहर को लौटा देखिए
Yes.
Yes, ma'am. Can I place Millard?
Yes. Yes.
Counter affidavit stated to have been filed by Nilachal Refractory, opposite party number 6 on 15th November 2021. Served on D.K. Mahantil on an additional. D.K. Mahantil, an additional government advocate, placed before the court that certain written instructions received by him from collector and district magistrate Dankara, stating as per report of the Tahsildar Odapada, the company has stating
neither
that
purchased the land,
neither purchased the land,
nor vacated the land,
nor the vacated intervention petition before the honorable court. Millard, the lands were taken over possession.
So you just read carefully, sir.
Yes, Millard.
This is something in your favor and you're rushing through it.
It is totally
sorry,
in his
Millard,
favor.
not the order I didn't get. Sorry, very sorry. I beg apology, Millard. From the affidavit earlier filed by the Tahsil, that appears that the acquisition proceeding was in fact already initiated and had progressed up to the stage of issuance of declaration under 6(1) of the Land Acquisition Act 1894. It could not proceed further due to paucity of funds. As a result, no land acquisition award could be passed in respect of the land of the petitioner, which is presently under occupation, OP number 6. The stand of the opposite man number 6 that the amount of entire land has already been deposited by its predecessor interest to the state government. The government is, I'm obliged, I'm sorry. I beg again apology, I beg again apology.
Yes,
yes, I have filed the affidavit. Your lordship may kindly see.
Where is that? You've seen the affidavit of the government?
Yes, I have seen the affidavit. Let him place
what is dated 17th December 2021.
Where is that?
17th December.
Filed on 20th December through email.
No copy has been given to me. But anyway, let him place.
We don't have a copy, sir.
I have.
Where
it
is
is already served.
No copy has been given. No copy has been given.
Okay. The affidavit dated 17 December 2021.
The dated is 17 December, but filed on 20th December.
Filed on 20th December by the government. Be brought on record and also be served upon Mr. Shaktidhar Das, learned senior counsel appearing with the petitioners forthwith. call on 21st. So 21st February we'll hear it.
All right, all right.
My lords, I am BP Tripathi appearing on behalf of opposite party number 6, my lords.
All right.
Copy may be solved, my lord.
Yeah, as well as opposite party number 6. All right.
Obliged, my lords.
Item 32. Item number 32.
None appears dismissed for non-prosecution.
Item number 33.
Mayor, please. In this case, Miller, the petitioner applied for shifting of the liquor shop of the opposite party.
Sir, all this is now infractuous. It's infractuous, sir, now.
It is infractuous.
The petition has been rendered infractuous and is disposed of as such. Yes.
Item 34.
May I please, Your Lordships. Your Lordship, may kindly be pleased to turn to page number 111 for a moment. That is the reply submitted by the police authorities under the Right to Information Act, whereby it is evident on record that the day by day the missing of child persons are increasing a lot.
And this is all too broad-based, too wide.
It is a very serious concern, my lord. And though
the point is, how does one deal with, if you have such a broad-based prayer, it's very difficult to deal, for the court to deal with it. You give us particular instances and say these children have gone missing, they've not been traced, we can understand. This will lead us nowhere.
With much humility, my lord, the petitioner.
And sir, you'll have to follow up on these matters on a regular basis. It's filed in 2013. The last listing is 2014. No effective order. We are listing it on our own, so it is coming up. Otherwise, as counsel for the petitioners, you are not bothered. If it is child trafficking, how can you be relaxed for 8 years?
Your Lordship, may kindly please to.
No, you file a proper petition with hard facts, at least giving us 4 or 5 concrete instances, and then we can follow up.
I have also given the instance that the media reports, my lord, this
instances of 2013 we can't take up now.
And your Lordship,
please try and understand.
There only one prayer of the petitioner, my lord.
I'm sorry to say, PILs have to be dealt with very seriously. The more serious the issue, the more frequent must be the listing. You can't put such a serious issue to the court, forget about it for 7 years.
At this juncture, my lord, I respectfully submit the lordship that the prayer number D may kindly be considered by the state authorities, my lord.
No, not like this, sir. You give concrete instances. Please, I'm trying to tell you, and not instances of 2013, which suddenly, when the court on its own lists in 22, you will say, please take it up. On your own, you people don't mention these matters. It is never listed.
And in the meantime, the Supreme Court was
appalling. It is appalling that such a serious issue is treated so casually by the petitioners.
I respectfully pray your lordship's kind indulgence so far prayer number D is concerned.
In fact, if the petitioners are not serious, if petitioners are not serious, why should we entertain this kind of a PIL? We'd rather have a serious petitioner, a petitioner who is really concerned.
I respectfully pray your lordship kindly visualize the predicament of the.
This was last listed in 2014, sir. I have been Chief Justice here since January. Not even once, Mr. Das, have you mentioned this petition for listing.
I'm sorry, man.
And you know that this bench takes PILs very seriously.
I'm deeply sorry, my lord. I'm deeply sorry.
And there is no seriousness, therefore. Today it is coming up because on our own we are listing old matters.
We are really obliged, your lordship.
This petitioner has not been bothered to do anything.
Your lordship kindly have a sympathetic view on the larger interest of the children.
This is not about sympathy, sir. Please.
On the children's, my lord. On the children.
This is not sympathy for the children. It is about their rights. This is not sympathy. Please. It's about the rights of these children, and we have to be serious about it.
My lord.
It is strange that a serious issue of child trafficking brought to this court in 2013 has not been followed up by the petitioner. for the last over 7 years. Full stop. This makes the court doubt whether the petitioner is at all serious about the issue. Paragraph. Further, the prayers are so broad and sweeping that it would be impossible for the court to pass any effective orders, the implementation of which can be monitored. Full stop. A serious petitioner has to do homework, point out concrete instances, and ensure that the petition is taken up at regular intervals, regular short intervals, so that the issue can be tackled effectively. Full stop. A lackadaisical PIL petitioner does great disservice to the cause. Paragraph. Permitting the petitioner to file a fresh petition with concrete instances, accounting for all the steps taken in the meanwhile by the government to tackle the issue. The petition is disposed of. Yes.
Item number 35.
No instructions, my lord.
Counsel petitioner states that he has no instructions. It's disposed of as such.
Item 36.
The lordship, the matter has become infructuous.
Counsel petitioner states that the petition has been rendered infructuous. It is disposed of as such.
Item number 37.
37, my lord. I am appearing on behalf of Mr. Mantri for the opposite party. He has a bereavement in his family.
Opposite party or petitioner?
My lord. Opposite party, my lord.
Who's for the petitioner?
I am for the petitioner, my lord. In this case, this is a PIL, my lord. The petitioners are aggrieved by the inaction of the opposite parties, particularly the opposite party number 1 and 2, that is collector and Tahsildar, in the matter of
Sir, if you are so concerned for the last 7 years, you did not even mention it once for listing.
My lord, the lands reserved for public purposes, cremation ground, gocher, and other purposes, which is under Annexure 1. But the opposite party number 3 to 7 and other persons have occupied and encroached the government land and raised
Yes, of 2014, and it has not been listed for 6 years.
My lord, it has been notice has been issued, my lord. Your lordship, kindly consider the grievance of the petitioners, my lord. Your lordship, kindly consider the opposite parties and other persons have occupied and encroached the government land, which are reserved for the public purposes, my lord.
Sir, if we had not listed it today on our own, if the court had not listed this petition on its own today, would you have ever mentioned it for listing?
My lord, as it has been...
No, one minute, just answer this question. Assuming the petition was not listed today by the court, would you be interested in the petition being listed at all?
My lord, it has been, as it has been listed, my lord, I am...
Therefore, you are submitting. Otherwise, if it is not listed, you will not be bothered, correct?
I'm sorry, my lord.
No, don't be sorry. You have to be sorry for your clients. Your clients came to you 7 years ago saying, sir, do something about this illegal encroachment. You have relaxed. Court issued notice in some 2015. We are in 2022. How do you expect effective treatment of such issues, sir? If you just relax for 5 years, 6 years. In the meanwhile, will the encroachment have grown or would have reduced, according to you? Even as a lay person, would the encroachments have grown or would it have reduced in the meanwhile?
My lord, they have encroached.
No, will it have grown? Will there be more encroachments or less?
When grown, my lord, they have acquired.
Grown. So by your inaction, you have actually encouraged them.
My lord, necessary order.
You don't know. Do you know what the present position is in that area? You don't know.
No.
You don't know.
My lord,
when did you last visit the area?
Your lordship, kindly may I pray.
Sir, when did you last visit that area?
My lord, my short prayer before your lordship, my lord.
You will not answer questions. We are not obliged to listen to you then. You have to answer the question, sir. You are a PIL petitioner, correct?
My lord, so far as the instruction received from my client is concerned, my lord, they have encroached and encroachment has grown, my lord. And they have acquired the government land and they have raised construction over that, over those land.
Nobody could have acquired government land. I don't know what he is submitting. Who has acquired government land? How can government land be acquired?
I have implemented them opposite parties.
Encroached, all, everything, same word. Inquired, encroached, acquired, and all is the same meaning. What are your instructions? Notice is issued in 2015. We are in 2022. Nothing. Nobody's bothered, sir. A notice was issued way back in this petition way back. This PIL, which complains of encroachment on government land by opposite parties, 3 to 6. Notice was issued by the court way back on 30th April 2015. Thereafter, even the petitioner, neither has counter affidavit been filed by the state, nor has the petitioner bothered to have the matter listed. So today the matter has been listed on its own, in its own turn. Paragraph. While the impression that the court gathers is that the petitioner is not really serious about the issue, still the court cannot ignore it if the facts averred are true. So consequently, a direction is issued to the collector Jharsuguda, opposite party number 1, to examine the petition and the representations enclosed, and after issuing notices to the petitioner as well as opposite parties 3 to 6 and any other person who may in the meanwhile have encroached on the government land in question, pass a reasoned order issuing directions, appropriate directions in accordance with law, not later than 4th April 2022. The order be made available to the parties not later than 11th April 2022. The petition is disposed of.
Item 38.
Item 38 has become infectious.
Counsel, the petitioner says the petition has been rendered infructuous. It's disposed of as such.
Item number 39.
My lord, I mean BC, my lord. My lord, on behalf of BK Raj, who is for OP number 2, may I permitted to pray, my lord?
No, your OP number 2.
My lord.
First, let us hear the petitioner, madam.
Yes,
my lord, pardon, my lord, he is suffering from high fever, my lord. He is isolation.
Madam, let us see who is appearing for the petitioner first.
I'm appearing for the petitioner, madam. I'm appearing for the
I see. All right. Counsel for OP number 2 is stated to be unwell. List on.
Lord, since your lordship is passing an order on the prayer of the opposite party, may I just intervene?
Yes.
Lord, I have applied for a formal amendment. Can it be allowed so that matter can be exhaustively dealt with?
You applied for a permanent?
My lord, a formal amendment. IA number 1766.
All right.
Yes, ma'am.
All right. Amendment petition that IA number 17366 of 2019 for the reasons stated therein, and without prejudice to the rights and conditions of the parties. The application is allowed. The amendment as per the schedule is allowed to be carried out in the main petition. The consolidated petition will be filed within a week. Paragraph. Counsel for opposite party number 2 is stated to be unwell. List on 4th May.
Yes, Lord.
All right.
Hearing item 40.
I appear for the respondents.
Yeah, please, your lordship.
Your Lordship, on 7th May 2021 has admitted this tax appeal and framed 4 questions of law. By the order dated 7th May 2021.
Yes.
Your Lordship got it?
Whether Senvat credit.
Whether Senvat credit can be allowed to an assessee on capital goods used in the factory, power plant of KMCL. KMCL is the appellant member. Meant for another company assessee, NINL, for manufacture of final products which are different and distinct. That is, KMCL manufactures coke and NINL manufactures teas are the final products. The next, whether under Rule 57AA of the Central Excise Rule 1944 or Rule 2 of the Senvat Credit Rules 2001, the capital goods used in the power plant of KMCL is senvatable when the final product power is non-excessive. 3. The KMCL having consciously established the captive power plant within the premises of another company NINL, which requires 75% of power, whether Senvat credit can be allowed on capital goods for the captive power plant when it is not exclusively used in the manufacture of coke, that too when the coke oven plant is situated at a different place. Whether the captive power plant of KMCL consciously installed centrally within the premises of NINL to meet 75% of NINL's power satisfies the definition of factory. These are the 4 questions of law, Your Lordship. Your Lordship, the brief fact of the case is that KMCL, the present appellant, and NINL are both 2 sister companies.
There was a news item that NIL has been sold
to Tata.
So you have to amend the petition?
It has not, I think it has not been sold to Tata. There is a proposal that Tata will take over.
Okay.
That is my instruction.
All right.
Well, at that time, the KMCL, the present appellant, and NINL are 2 different companies.
Yes.
Though, and also the sister concern, my lord. What has happened, my lord? KMCL has established a plan, power plant,
within the premises of NINL.
For the purpose of NINL powers and inside the factory premises of NINL. So the sole, if your Lordship will take, this is the ground plan submitted by KMCL, my lord. On the right hand side, my lord, this is the area of the KMCL, coke oven plant, my lord. The next area is belonging to NINL, and the middle of the NINL factory, KMCL has established his power plant for supply of the power to NINL. So the question arises whether these 2 factories of KMCL, one is coke oven plant, another is power plant, can be termed as one factory. So that Senvat can be taken credit on. And the second question your Lordship will appreciate.
No, so the concept of a captive power plant is the question, right? Merely because a captive power plant is located somewhere else will not make it not a captive power plant.
Absolutely, your Lordship, absolutely.
But
right.
if the power generated is not used by the plant, but used by some other plant,
yes, ma'am,
then it can't be a captive. That's your contention.
Yes, my lord. Because there is no interlinkage process, my lord. There is no
captive itself means that somebody else is not using it, you yourself are using it.
Yes, my lord. Here the case is that admittedly NINL has used it. 75% of the power has been used by NINL.
So, but what is the holding subsidiary relationship between the 2 companies?
My lord, if your Lordship,
when you say sister concern, what does that mean?
It's a sister concern. It's a sister concern.
What is the shareholding
your
pattern?
Lordship, your Lordship, kindly turn to page 15.
Page
15, 1/5 of the paper book.
Yes.
Relationship between NINL and KMCL. You also got it?
50 or 15?
1/5 million of the paper book.
Paper book is separate.
This spiral binding paper book I have submitted on 18/12/2019 million. 18 December 2019.
Do not scan it.
This is annexure 3 of the so-called notice at page 15, 1/5.
Yes. Relationship.
Relationship between NILN and KMCL. It is submitted by the appellant to the adjudicating authority, the so-called authority. Neelachal Ispat Limited, NINL, has been incorporated as a company under the Companies Act 1956.
This is submitted by the SSC.
It is submitted by the assessment. My lord, kindly come to 6 million, clause 6 million. NINL proposes to sell BF gas, converter gas, nitrogen gas generated from its steel plant as well as provided water to KMCL and purchase BF coke, LP steam, HP steam, coke grease and electrically produced generated from KMCL's coke oven plant and power plant. So there is a agreement for sale and purchase. So these are two totally different companies. Then, my lord, kindly turn to the finding of the Lord Tribunal.
So strangely, NINL and KMCL are not in a holding subsidiary relationship at all. They're not even that.
No,
it's only that they have common promoters. MMTC, EPCOL are the common promoters for both companies.
In fact, Manoj, if I may point out, sorry to interrupt, Manoj, in 2004, both the companies have merged and it became NINL now from 2004.
No, but at the relevant point in time when this...
it is 2001, Milord. 2001.
2001, they had not merged, sir.
They are not merged, Manoj. In fact, in the page 15, Manoj sees the paragraph 3. Just to, I'm sorry to interrupt, Manoj. Just paragraph 3, Manoj, of this page 15, which my learned friend read out.
Yes.
Because of both NINL and KMCL belong to one single feasibility report, wherein all technical features and service network are designed in a manner to make an integrated conventional iron steel.
That's right, sir. So, but that is still to happen in future. In 2001, there were still two separate entities.
Yes, well, that's a fact that cannot be disputed. But the question of law, Manoj, in fact, what my friend is submitting, whether the fact that 75% of the electricity is being sent to NINL, will it disentitle me for the credit of the duty paid on capital goods or not, is a question which Manoj has been addressed by several other high courts on this point directly. I will just take Manoj to remember.
All right. Well, I'll come to that point also, what my learned friend is submitting. Well, kindly come to page 104 of the paper. The finding of the tribunal. Last two line, page 10, para 10 million. After, my lord, got it?
Yes.
After hearing both the sides and considering the material on record, it is found and held that on consideration of the definition of factory when section 2
under
section 2E of the Act and the guideline of CBEC issued in the contention the fact of the coke oven plant and power plant of KMCL located at different sites, and that is not inside the premises of the coke oven plant, cannot be denied, especially when land has subsequently been transferred to KMCL. But at the point on the relevant period, when the SENVAT credit has been taken by the KMCL, at that time there are two separate companies. Only for the reason that it has been subsequently merged with the NIL, that cannot be held that the person who has taken the SENVAT credit on the year 2001 is eligible to take that SENVAT credit, even if this capital goods has not been received in the factory premises of the appellant. And it has been the final product, that is power plant, is not being used. It has been used for the purpose of the NIL.
Yes, let's hear Mr. Raghavan.
The issue for my large kind consideration is whether capital goods which are installed in the power plant, the definition of the factory of the respondent here, which are used for generating electricity, part of the electricity is being used by KMCL undisputedly. The remaining part is being used by NINL. Will this particular factual scenario disentitle Konark Medcor KMCL to the eligibility?
The expression captive use means what?
The captive use, that has no relevance as far as the SENVAT credit rules are concerned. We are supposed to interpret the definition of the term capital goods and what are the rules prevalent under the SENVAT credit rules. I will take to the relevant portion. As I pointed out, in terms of the feasibility report, initially all this was supposed to be one single integrated steel plant to be set up, right from the start of the coke till the manufacture of the final product. Because of the various requirements at that point of time, strategically they formed two separate companies which immediately got merged, and after that it been functioning as one.
No, not immediately. Merger happened in 2004, sir.
4 minutes, correct, 4. Because why I am saying immediately is because it is around that time, 2003-4, that the entire factory of NINL started commencement of production. This initial period when I took the credit was when the factory was being set up for manufacture of the.
You will get the benefit as and when you merge. You will get the benefit from that.
No, in fact, I will just point out. In terms of the credit rules, my being a captive power plant does not have any effect as far as the SENVAT credit rules are concerned. The relevant provisions for allowing credit of the duty paid on the capital goods, which the tribunal said that because part of the electricity is used, my lords, I have filed a compilation of 91 pages.
You have that compilation, Mr. Mishra?
I do. Compilation of totaling 91 pages, Miller.
All right. Yes, sir.
My lords, in that page 25, my lords.
Yes.
57 AC, my lords.
Yes.
The SENVAT credit in respect of inputs may be taken immediately on receipt of the inputs in the factory. We are not concerned with inputs. The SENVAT credit in respect of capital goods received in a factory at any point of time in a given financial year shall be taken only for an amount not exceeding 50% of the duty paid on such capital goods in the same financial year. The balance of the SENVAT credit may be taken in any financial year subsequent to the financial year in which the capital goods are received in the factory of the manufacturer, provided the capital goods other than components, spares, etc. are still in the possession and used of the manufacturer.
In the factory of the manufacturer also is important, sir.
Yes, in the factory of the manufacturer. This power plant, which is in the middle of NINL, and the coke oven plant, both of them are registered as my factory under the central excise law. That is permissible, that has been done. Now, my lords may kindly come to page 26, the relevant provision which falls for my lords' kind consideration. Rule 57 AD, my lords. May I read, my lords?
Yes, please.
My lords, in page 26, sub-rule 3 of Rule 57 AD. No credit of specified duty shall be allowed on capital goods which are used exclusively in the manufacture of exempted goods other than final products which are exempt from the whole of duty of excise leviable thereon under any notification where exemption is granted based on the value of clearance. We are not considering the second part. We are considering the first part, my lords. No credit of the specified duty shall be allowed on capital goods which are used exclusively in the manufacture of exempted goods. So unless and until the capital goods are exclusively used in the manufacture of exempted goods, there is no other provision which will deny the credit to me. In my case, admittedly, the capital goods were used for generating electricity. Electricity was partly used in my own factory for manufacturing dutiable coke. The remaining quantity of electricity, 70%, was used in NINL again for manufacture of dutiable final product. Since my capital goods have been used partly for manufacturing dutiable goods in my factory, this provision will not apply and therefore credit cannot be denied. The second question of law which my lords have referred, which my learned friend has...
No, but does Neelanchal Ispat manufacture any exempted goods?
No, my lords. They also manufacture dutiable goods. Neelachal Ispat also manufactures various iron and steel items, pig iron, sponge iron, and other products. All of them are dutiable. Therefore, my lords, unless and until I use the capital goods exclusively for manufacture of exempted goods, credit cannot be denied. And this precise question had come up for consideration before the Honorable High Court in the case of HEG in my same compilation, page 37.
Yes.
And those cases are totally distinguishable in the present case of the appellant. In the present case of the appellant, the factory is not situated inside the same premises. So it is not coming under the definition of factory.
No, there is no requirement of the location of the factory, sir.
Yes, my lord, it is required. Your lordship, kindly turn to the compilation page, page 4, my lord. Definition of factory, my lord.
1 minute.
It is definition 2, subsection E, my lord. Factory.
Yes.
Means any premises including the precincts thereof, wherein or in any part of which excisable goods other than the salt are manufactured, or wherein or in any part of which any manufacturing process connected with the production of these goods is being carried on or is ordinarily carried on, my lord. It should be in the premises, my lord.
No, or.
Or
They are all separated by or, sir.
Is, my lord. There is a clarification in this regard, my lord. If it is being separated by a rail line or road or canal, then it can be termed as inside the same premises. Here it is not like that. Here it is being separate. It is being...
No, so the negative doesn't. So unless there is a notification or a clarification that says it cannot be outside the premises or in somebody else's premises, there is no bar to that. As long as it's identified as your factory.
Your lordship, kindly turn to that notification, which my lord and friend has quoted. Page 124, madam, of my paper book.
Yes.
Para 11. Your lordship got it?
Yes.
The respondent craves leave of this honorable court to rely on the guideline issued by the Central Board of Excise and Customs in their manual of supplementary instruction dated 1st September 2001. For ease of reference, the same is extracted below. separate registration is required in respect of separate premises, except in cases.
Construction was issued only on 1/9/2001.
Yes, Milo.
But this was already set up before that.
It has been set up before that, Milo,
So
but
there's
it is
no
only a
requirement
clarification, Milo.
No, so there was no requirement of separate registration. Before this 1/9/2001, there's no question of a separate registration required. So this is prospective, sir.
My lord, if the factory are not situated in the same premises, it
No,
is
no.
situated in two different premises.
Why? No, it only if they are separated by a road, only separate registration would require.
Yes, Milo. Here it is not been separated by a road.
No.
Or canal,
So in that case, if there is such a factory after 1/9/2001, then separate registration
no,
is
Milo,
required.
not required. In that case, it can be termed as one factory, Milo.
No, sir. Just try and clearly understand. From 1/9/2000 onwards,
Milo,
where two or more premises are part of the same factory but are segregated by a road or canal.
My lord.
Except. So those factories do not require registration.
Do not require any registration.
1 minute. But factories which are not separated by a road but are in separate premises,
they require a registration.
But only after 1/9/2001. So try and follow this, sir. Only after 1/9/2001, this requirement of separate registration came about.
If your lordship will come to the registration part also, I think.
Because this, which is the period which we are talking about?
It is for the period 2001, Milo, March to
July 2001.
March to July 2001.
So naturally, this will not apply, sir. This instruction will not apply at all.
It is only a clarification with regard to taking
even
separate
a clarification,
registration.
sir. Separate registration requirement started only from 1st September. Merely prior to that, merely because there is no separate registration will not mean it's not part of the same factory. Are you following?
My lord, my lord, in this case, in the present case of the appellant has not started his coke oven plant at that time. Only he has started the power plant for the power requirement of the NIN.
It's all right, but you're not disputing that there is a coke oven plant which the appellant has and a power plant that the appellant has.
But those two are separated by some other things, which is.
No, other things is what? Nothing.
It is situated inside the premises of the NIN.
So where is the prohibition for that, sir? You must show us some law which prohibits one factory, one entity's unit being located in some other unit. There should be a prohibition on that, sir.
The definition of factory, which
the definition of factory does not prohibit this.
It has to be in the same premises.
No. Means any premises including wherein or in any part of which accessible goods are manufactured.
Yes, my lord. Yes, my lord. I'm not denying.
Precincts and premises. Premises can be even multiple premises.
Means
it
any
has to
premises.
say, otherwise then you have to use the word premises, one contiguous premises. It doesn't say that.
Means any premises, my lord. Any premises, so including the presence there.
If you broadly interpret it, premises could be even separated.
My lord.
It could all be the same premises. The question is, do you want to narrowly interpret it, or purposive construction would be that you interpret it as broadly as possible?
And the second fact, which is pertinent to mention here, that the coke oven plant and the power plant, these are the finished product are different, my lord. The power plant finished product is meant for NINL as admitted by the KMCL, by the present respondent, my lord. And some of the power is in future may be required by KMCL.
What?
In future, my lord.
There is no requirement, because when you started, you talked about captive use. There is no such requirement here.
No, not captive use. Not captive use.
So if there is a captive use requirement, what you argue may be right. Yes, if there is no captive use requirement, then this is not a problem.
But there has to be some interlinkage, my lord, so that it can be said that the power is used for the purpose of the finished product. To get that input tax, Senpat credit, my lord, if your lordship
will come, finished product has to be a dutiable product. That's all is the requirement. There's no
My
other
lords,
requirement.
in the case of HEG, which I just pointed out, instead of giving it to another related entity, there the power was given to the state grid. My lords, may please come to page 37 of my compilation.
Right.
Please, page 37, my lords.
I'll go to that. Before that, I just want to bring to my lordship's attention sub-rule 2 of rule 57 AC, my lord, at page 25, which my learned friend has read out, my lord.
Right.
The sendback credit in respect of capital good received in a factory at any point of time in a given financial year shall be taken only for an amount not exceeding 50% of the duty paid on such capital goods in the same financial year. Before that, the sendback credit on respect of inputs may be taken immediately on receipt of the inputs of the factory of the manufacturer. Then your lordship will come to the
57 AD3. That's what he was reading.
Yes, but that's the only rule which will deny credit to me if at all I fall within that rule.
If he manufactures exempted goods, he won't get any credit.
Here, my lord, at that particular time of period, the KMCL is manufacturing electricity. He is not manufacturing coke oven, my lord. The present respondent was manufacturing only electricity.
There's no bar on manufacturing.
And the final product is the electricity at that time, which is exempted. At that time, the final product of the respondent was only electricity.
No, when did the coke oven plant begin manufacturing?
It has started manufacturing, as per my interest, in the year 2002, million.
My lords, if I may just point out, my lords, under the credit rules, under the SENVAT credit rules, a person.
Let me submit. Just permit me to submit.
I'm sorry. I'm extremely sorry.
I think they can go and start.
Your lordship, kindly turn to page 161 of the paper book. That is the Nilachal Ispat Limited documents, my lord. 161 of the paper book. Commercial production of S2L KMCL started on 1/9/2004.
Right.
So at that time, particular time, the KMCL was only generating electricity, which is an exempted goods.
Mm.
And your lordship, my lord and friend has cited so many decisions. I am relying on only one decision out of that. It is Maruti Suzuki. It is at page 78 to 89. Only one paragraph of the Honorable Supreme Court. At page 88, your lordship will come.
Yes.
Para 16. In our earlier discussion,
yes,
we are referred to two considerations as irrelevant, namely use of input in the manufacturing process, be it direct or indirect, as also absence of input in the final products on account of the use of the expression used in the relation to the manufacture of final products. Similarly, we are of the view that consideration such as input being used as packing materials, input used as fuel, input used for generation of electricity or steam, input used as an accessory, and input used as paints are per so also not relevant. All these considerations become relevant only when they are read with expression used in or in relation to the manufacture of final product in the substantive specific part of the definition. In each case, it has to be established that input mentioned in the inclusive part is used in or in relation to the manufacture of the final product. It is the functional utility of the said item which would constitute the relevant consideration unless and until the said input is used in or in relation to the manufacture of final product with the factory of production. The said item would not become eligible input. The said expression used in or in relation to the manufacture have many shades and would cover various situations based on the purpose.
So your point is electricity is not used to manufacture coke oven.
At that time, it was not.
So the only thing that was being produced was electricity, which is exempt.
It is exempted goods and it is being supplied to.
So even if electricity is used to manufacture by NINL of steel, that will not hold good.
That will not hold good.
Unless they show that both are one entity.
One entity.
Can we continue tomorrow?
My lords.
We'll just continue after the regular board.
2 o'clock, Mila?
Pastor matter item 27.
My lord, item 27 may be taken up after removal of defect, my lord. There is some defect in it.
Defects be removed, list after removal. Within a week, list after removal.
My lord. Oblige, my lord.
Right.